My name is Steve Bruno, Deputy Executive Director at TDLR, serving as presiding officer for the Electric Vehicle Supply Equipment Stakeholder Work Group. I want to welcome everyone. It is 1:33 on October the 15th. I'll remind everyone to please mute your mics and only turn them on when you're speaking, and please announce your name when you're speaking. Alex, could you please do the roll call?
Sure. Okay, Justin Wilson,
in attendance.
Denise Costarelli, Francesco Wall, Francesco Wall. If you're speaking, you're muted right now. Circle
Looks
back.
like she's here. Can we come back to her, Alex?
Yes.
Okay, thanks.
Lindsay Stagel,
Present.
George Johnson,
Present.
Brian Moran,
Present.
Josh Tierner,
Present.
Robert Pitzel, David Donahue,
Present. Hello, everybody.
Tyler Nicholson,
Here.
Michael Chamberlain,
Good afternoon. I am here.
Jamie Mitchell, Jamie Mitchell, you're muted.
My apologies, I couldn't find the unmute button. Jamie Mitchell with Austin Energy.
All right, thank you, sir. Mike Wisco, Francesco Wall, Ms. Wall, if you can hear me, your video is off and you're muted. Okay. Can we try it again? Okay. And Steve Bruno, presiding officer.
Yes, I am present. Thank you. All right, great. I'll ask if anyone has any comments regarding the minutes from the May 23rd meeting. And if not, then I'll ask for a motion and a second to approve the minutes from that meeting.
Motion to approve the minutes.
Thank you. Is there a second?
I'll second.
Thank you. Is there any objection to the approval of the minutes? All right, hearing none. We will consider those approved, Alex. That's all right. Okay.
And
who was the motion?
I believe Mr. Moran made the motion.
Right. Thank you.
And the second was Mr. Donahue.
Justin Wilson.
Aye.
Denise Costalari, Francesco Wall,
Aye.
Lindsay Stagel,
Aye.
George Johnson, Brian Moran,
Yes.
Josh Tanner,
Yes.
Robert Pitzel, David Donahue,
Yes.
Tyler Nicholson,
Yes.
Michael Chamberlain,
Yes.
Jamie Mitchell,
Yes.
and Mike Wisco. Okay, motion passed.
All right, thank you. We'll now go to item D, which is public comment. I don't believe anyone has signed up, who's outside of the work group membership. Is that correct? Do we have it, or do we have anyone who has signed up?
We do not have any public comments.
Okay, thank you. Then we'll move on to item E, our staff reports, and we'll get into what we're all gathered here today to talk about. I do want to do a brief introduction and just share some overview thoughts before we get going. Welcome everybody and good afternoon. It's really great to see you here. We've got several objectives to accomplish for this meeting. We are going to be discussing the draft rules as they stand today. We also want to share more details on some of our agency's processes and procedures, specifically with respect to licensing and enforcement and how those processes and procedures will impact this program. We hope that this discussion of what you can expect from us as the program continues rolling out will give you a better set of expectations. And we recognize that some of you may be familiar with us through some of our other programs that we oversee, but many of you are new to TDLR. And we're here to be partners with you in service to the public. We're not here to be a frightening regulatory monolith. I hope today's meeting will help further demonstrate that commitment and our optimism for the future of this program. Regarding the draft rules and all the comments that we've received and that we're going to talk about so far, I want to begin by saying thank you for that. I want to say thank you for your input. This process cannot work and cannot function without your input. I do just want to take a quick step back. There's some pretty important observations that I think are worth sharing about this particular program. If I'm not mistaken, we're going to be the fifth state to actually adopt rules regarding electric vehicle charging stations. Not only is it a new regulatory program, the technology itself is new. It's so new, in fact, that the tools that we will all be using to inspect these stations, aren't even fully developed. I think we all believe and recognize that technology has not stopped evolving, and I don't think it's going to stop. It's just getting started. And at TDLR, we definitely recognize that the companies you all represent are investing tremendous financial and other precious assets toward this technology. And we understand that some of you may approach government regulators with
A
caution.
little frustrating. I can't seem to
From
Yeah,
our perspective,
my audio on this meeting I'm supposed to be
excuse
in.
me. Oh, okay. Thank you. From our perspective, as regulators, our approach is to fulfill
minutes ago.
responsibilities assigned to us by the legislature by proposing rules
Okay.
that stay within the confines of those laws that they have passed. We attempt to fulfill those responsibilities by recognizing that we're not the subject matter experts. You all are. And no program, especially a brand new program with cutting edge technology like this, that's still evolving, is going to work without discussion and communication and understanding. Before we turn it over for the rest of the agenda, I want to broadly state that our goal is to first put registration in place. As the law and the draft rules state, compliance with manufacturer specifications comes later, and it comes in phases. In the transition language in SB 1001, there's clear forecasting there that tells us that we're going to be working on and discussing and regularly updating these rules through at least the year 2030. And this beginning set of rules that are eventually adopted for this program, we know because of the technology changing and because of the evolutions and revolutions of this industry, these rules will change and evolve. I think it's pretty reasonable to think that future laws could change as well from the legislature, and like the rules, they'll evolve as well with this program. I just want everyone to share, to know that at TDLR, we look forward to walking on this journey together with you. We're always going to work to understand the needs of the regulated industry and understand the expectations and assignments given to us by the legislature. And we're going to work to strike a balance between those two things. So let's get into a couple of brief presentations. As I said, we want to share a little bit more before we get into the discussion about the rules, about what you can expect as members of a regulated community from TDLR. So I'm going to be calling first on Laura Hernandez with the licensing division, and then I'll be calling on John Medlock with the enforcement division. Laura's going to give us a preview of what you can expect to see when you begin registering your devices. So Laura, I'll turn it over to you.
My name is Laura Hernandez, and I am licensing manager in the licensing division. My team will be handling the electric vehicle supply equipment registrations. And so we're excited. This program is going to be put into our Versa licensing system. The system holds most of our health profession licenses and also the transportation network companies. So we're glad to add, because this system will allow online registrations, online renewals, online updates, online payments. So we know that that is going to be very much more expeditious as far as getting these registrations to you all, for you all be able to go online. And so this first page of the report is just the portal. When you get into the to our system and you want to register the equipment, you'll get to this page, and here you'll be able to verify licenses. It'll take you to changing your address, renewing, and first you'll log in. You'll set up a login, username and password to log into your registration and manage your registration. We are in the middle of doing user acceptor testing, so that we can make sure that the wording is correct based on any rule changes, making sure that it's user friendly, and of course that it works properly. The next page just will give you the different kinds of things you'll be able to do. The first page is identifying who you are and going through that provider registration. And then underneath it, it gives you all the options that you're able to do online, which is going to be registering a new location, changing the location, renewing it, renewing contact information. And so there's not a lot of the paperwork and having to wait for mail to get here and for it to be processed and everything mailed out back to you all. So we are excited to be able to give this to be able to offer these different options for this program. And like I said, we are testing, and we're hoping to get this done so that we can start accepting registrations as early as possible for that March begin date. And we will have opportunities for somebody, if there's any companies that would like to, so to speak, be a guinea pig, to go through that process and actually do a real registration. It's something that we've started doing lately for a lot of the new programs, is to actually allow somebody to come in before, just to make sure that we can follow that process and make sure that once it rolls out to everybody, it rolls out smoothly. And
Laura,
I'm sorry.
Excuse me. Thanks for that reminder, Laura. And we will be reaching out to some of you in this work group for that help.
And that is what we are working on. And I'm happy to answer any questions that anyone might have in regards to registration process or anything else regarding licensing division.
I know it's a quick preview, and as Laura said, we're testing it and it's in development, but this is close to what you can expect to see once this launches. Does anybody have any questions for Laura?
Yeah, Brian Moran. Is it this is a component embedded in the current registration website, correct? Or is this a unique just for EV charging licensing?
Oh, no, this is a licensing system we use for almost all of our health profession programs. And then also for our transportation network company. So, it's a licensing system we already are using. Yeah, that we've been using since, I believe, 2015.
Okay, great. Thank you.
And Brian, this is very close to what it will look like when you see it within that overall system, the specific areas for EV charging stations.
Yep, great.
Okay. Thank you. Anyone else?
Yeah, this is Justin from ChargePoint. I had one question. So the rules envision, and not to get too much into the draft rules, but the rules do envision, an annual registration requirement. Does this have like an auto renewal function that folks can set up and kind of let it take its course without actively having to log in every year in order to register?
Yes. So what we will do is we'll send out email reminders, and that email will go to the contact person that'll be listed, and they'll get a reminder. And we do it about between 60 and 90 days in advance, so that you have plenty of time to go in and do that registration. And then if, say, in 60 days, the provider still doesn't renew, another one will go out, and another email will go out, so that you all have plenty of notifications of when that's going to be due.
But each year will take an active login. You couldn't say just, put in a credit card number, and as long as that credit card number is good, it would auto renew. Is that correct?
That's not an option that we have right now. Somebody would need to log in just to go through and review, make sure everything is still correct. There's no updates that need to be made. But yes, you would need to log in to renew that license or to renew the registration.
And then one other just kind of follow-up question. Does the system allow for multi-year registration? So if, could you do 2 years? Could you do 3 years? Does the system itself allow for that, regardless of what the draft rules say?
We set up the system based on the rules. So right now it's going to be configured for that 1-year registration. If that changes, then we can configure it to change. But right now it's set up to be in line with the rules.
Thanks.
Thanks, Justin. Great questions. Anyone else?
Steve, this is Mark Gladney. In regards to the recent question, the rules do kind of control the way that the process is set up to go. And I think one of the reasons why it may not be this auto renewal function that was mentioned by a board member was that we have a provision in the proposed rules that requires the provider to give an accurate account of all the active charging units at a location before they would make that payment. So if it was an auto renewal, if there were some units that were taken offline at a location, just removed or placed someplace else or whatever the case may be, if it was an auto renew, we might not be able to track how many charging units are at that particular location. So, configuring it in the way that it's configured kind of makes the provider to do that true up every year for the registration, at least until the process evolves and we may move to something else.
All right. Any other questions for Laura? Laura, thank you so much for being here. We really appreciate that. I think that's really helpful just to get an idea of, be able to see what things might look like in actuality. So thank you very much for that.
Thank you.
All right, John, could you give us a background on the enforcement process, please?
Absolutely. Good afternoon, everyone. Welcome to TDLR. And My name is John Medlock. I'm the chief prosecutor here at TDLR. So I'm kind of going to give you a little bit of background of the complaint process and kind of what the documents that we kind of work from that. Alex, if you could actually go to the flow chart that's on page 3, that's kind of where I'm going to start. The way the enforcement division is set up is we're set up with 3 different sections, kind of intake, investigations, and then prosecution. This flow chart kind of flows you through the process as I'll kind of be talking about it. Essentially, in intake is where most of our complaints start or originate. A consumer will write in or go through our online system to file a complaint with us. And the intake's job is to determine whether or not we have jurisdiction over that. They basically ask, is this a program that we regulate? Because we do have quite a few programs that we regulate. And then after determining it's a program that we regulate, they'll determine whether or not one of those allegations in that complaint alleges a violation of a law or rule that we currently have. After they make that determination, they'll kick it over to our investigation section. In our investigators, we have both field investigators and those here housed here in Austin. But they'll do exactly what you would think an investigator would do. They'll go out, they'll ask the who, what, when, where, how, why questions. They'll go out and try to gather any evidence that there might be, obtain any witness statements. Occasionally, they will employ a subject matter expert. This usually occurs in a lot of our health-related programs when we have standard of care issues. They will collect all that evidence, all those statements, occasionally some actual physical evidence, but for the most part, they'll write up their investigative report. They are not making a determination about whether or not a violation has occurred. They're just, detailing all the facts and putting that into their investigative report, collecting, if there is an expert report, collecting that as well. And then they send that over to the prosecutors. The prosecutor's job is to determine whether or not an actual violation occurred. They do that by reviewing all the evidence that the investigators have collected. Occasionally, there may be times that we send back cases for further investigation because it may be something that the prosecutor wants a little bit, something a little bit more flushed out. But ultimately, the prosecutor has about 3 kind of choices that they can make. They can close the case with no further action. They can issue a warning letter, or they can issue what we call a notice of alleged violation. If we're closing the case with no further action, that usually occurs because after review of the evidence, we determine that there isn't sufficient evidence that a violation occurred. It could also be that the complainant has decided to withdraw the complaint for whatever reason. Sometimes parties work things out during the course of a case working its way through this process. It could just be that the complainant no longer wants to go forth with the action. Also, another way we close the case is because there's some sort of informal resolution that has occurred. Maybe the complainant has been made whole by the respondent through some form of restitution or refund, or maybe they came back out and fixed the issue that was the source of the complaint. So we'll close those cases out. Now, the next step is if sometimes that there is a violation that maybe has occurred, but some corrective action has been taken, we'll look to issue a warning letter versus a closure letter, or even the notice of alleged violation. The important thing to remember is if you do get one of these warning letters, these are not considered to be disciplinary action. We do recognize that sometimes mistakes are made. Maybe some processes aren't as tight as they need to be, but when respondents take action to make those corrective modifications, we don't necessarily want to hit them with a notice of alleged violation. Sometimes a warning is sufficient to get the message across. The final kind of thing that we can do in the prosecution section is actually issue that notice of alleged violation. Again, that comes after reviewing all the evidence, whatever that might be in terms of statements, documents, sometimes tangible evidence. And we've determined that there is sufficient evidence that a violation has occurred. We will draft up this letter and we will consult with our enforcement penalty matrix, which is part of the enforcement plan that I'll talk about here in a little bit. But once we do that, that basically gives notice to the respondent that the department is seeking to either sanction you with a penalty, sanction you with an actual license sanction to your license, or both. This does trigger the due process rights for the respondent, in which they can ask for a hearing, or they can also, come into an agreement with us. The results of an NOAV typically come down to either an agreed order, which means the parties have come together to determine that, yes, there was some fault, but we're willing to either rectify or make some kind of penalty payment to the department. Or they can trigger a commission hearing or commission, a right to a SOA hearing, which SOA is the State Office of Administrative Hearings. So if you ask for that hearing, we will actually go to the State Office of Administrative Hearings. We'll put on our case. It is very similar to what you would see in most civil courts. We don't have a judge and jury. We do have an administrative law judge, but we do have our openings, closings, witnesses that we come up there. We present our evidence. The SOA ALJ, or the administrative law judge, will issue what they call a proposal for decision, or a PFD, which basically says that based on the facts and the law that is applicable here, this is what I think should happen. And I think that's kind of an important distinction. It's not what is going to happen, because we do have to take those proposal for decisions before our commission, and our commission will ultimately make the determination about whether or not they uphold that PFD or not. The third thing that can possibly happen through a notice of alleged violation is a default order. Default order happens after we send the notice of alleged violation, and there's a 20-day period of time in which the respondent has to respond to us, whether they want to come into an agreement or they request that right for a hearing. If we do not hear anything from that respondent, we will send them a second letter called a notice of default, which basically says, hey, if you guys don't take action on this, either to come into some kind of settlement or request a hearing, then we're going to take a default on this notice of alleged violation. And then after another 15-day period, if we do not hear anything back, we'll go ahead and move for a default order, which is issued by the executive director. So that's kind of the life cycle of most of the cases that we have here at TDLR. Kind of back up to the beginning, Alex, those first couple of pages, this is the enforcement plan. I talked about a penalty matrix. Essentially, this enforcement plan is kind of the preamble that you see here of how we get to whatever license penalty or license sanction or license penalty that we go after. These are kind of the like I said, preamble documents to that. There are factors that we consider when each case that we have. It's on that last page there, Alex. It's 6 different factors that we do consider for every case. You know, it's whether or not the severity of the violation, whether it was willful or intentional, whether they act in good faith to mitigate violations. So we do take into consideration all these 6 factors. But what we do is something a little bit unique, is each program has what we call its own penalty matrix. And basically what we do is when the law is there and the rules, we take all of those and we put them into groupings of what we consider to be like violations, and again, by like severity. The way we typically do this is we have 4 classifications, usually A, B, C, and D, with A being the least severe violations, all the way to class D violations, which are the most severe type violations. We do this so that across the program, the prosecutors can have a level of consistency in charging similar violations in similar ways. We don't want one person charging really high and one person charging really low for similar violations. We want that consistency across the board as best we can. At the same time, too, we come to develop this penalty matrix with the help of work groups within each of these different boards that we have. So we will get those together. We will draft our best effort as to what we think is which these violations should and what categories they should fall into. At the same time, too, we meet with that work group to say, hey, you guys are the experts in this industry. You tell me, is this something that is a little bit more severe and needs to be moved up to a higher range, or is this something that's not as severe as what we initially thought it was and can be lowered down a little bit? But we'll do that in consultation with that group, and we'll get some sign off before we actually publish and start using that penalty matrix, just so you guys have a little bit of input into the process as to what it is that we will be charging and not charging. But that is what I have to present today. And if you have any questions, I will be happy to answer anything.
I had a question on we were talking about including something about willful vandalism of charging stations, which seems to be one of the primary reasons for being inoperable. Does the agency have any input into that? Any recourse, or should that be noted in the regulations to provide some type of deterrent?
Are you talking about if somebody like vandalizes a station outside of y'all's control?
Yes, yes, which, I mean, I think we agreed the last time that that's one of the major causes of sites being inoperable, that, willful vandalism. It seems like
Yeah.
that's a problem, something within the kind of the rules, regulations that would, identify some penalties to provide a deterrence.
Typically, we can only go after the people that are regulated by the industry or people that are operating outside of the industry but purporting to use the license. So if it's an act of vandalism that is occurring to one of these devices, that's more of a law enforcement matter, unfortunately. Some of our programs do have some criminal statutes built into them that we at TDLR cannot enforce, but other law enforcement agencies can use to enforce.
I wonder if any other workforce members have any experience with other states maybe doing something a little more proactive to address what is a major cause of outages.
And I will just say this as well. If a complaint comes in based on something defective with the charging station, but through the course of our investigation, we find out that it was because of vandalism outside the control of the respondent, we will probably seek to close that case because we do understand that, things like that will occur, unfortunately. And so it is not, we will not look at it as to the responsibility necessary that the respondent, if they can show that it was actually vandalism.
Thanks for that, John. And just real quick, on your last point, it may be a requirement of other law to add in more severe penalties for those who vandalize. But I think an important thing to keep in mind that John said was that, we can only write enforcement actions for those folks who we regulate. Obviously, we don't regulate, the thieves, but there can be other parts of statute, right, that could be addressed to help enhance penalties, because we certainly do understand and appreciate that that's something that's impacting this industry. Did you have I think I can see, Justin, you have your hand up. I don't know if others do as well, but please go ahead.
Yeah, thanks, Steve. So this is wonderful to see. I hope this is something that can be circulated for us to get a more thorough look at. And an enforcement plan is great. I think it provides a lot of transparency, and we can take this we can table this and have discussion about it later. But I guess I'm equally, if not more, interested in what the outreach plan is to let people, especially those who have already installed stations, about these regulations going into effect so that they can comply with the laws within the timeframes that are needed. So enforcement plan, great. What's the outreach plan to let people know what they actually need to do?
Thanks for that. Let me start with that one. And John, I'll let you come back in. The enforcement plan will be coming later as part of the process. But as far as, it's a great question. It's a new program. So requirements have not been in place before. In addition to being a new program, it's all the things I said about the beginning. It's new technology. It's emerging. It's advancing. It's something that no one really has a full grasp with their arms around it yet. So we will do everything we can, working in conjunction with you and with the industry, to help get the word out. Our approach to regulation, especially in a new program, is first to inform. There are going to be specific dates, and I think Mark will have a couple of comments on this as well. But there will be dates that are noted in laws and rules for requirements for things to be in place. And then there's also the approach that we'll bring, which is to work with you. We don't want to be the folks, just waiting for the gates to open so we can go and pounce and start writing up possible enforcement actions. That's not the way we approach things. We want you, first of all, to understand what the rules and the laws say. From our point of view, I talked about that importance for us for understanding early on. We want to make sure that you all understand what we're seeing, and that we understand what you're seeing, and that we're able to communicate and talk about what those expectations are. We have often used the first, 6 to 12 months of a new program to sort of roll things out and continue these conversations so that you all, again, have as much chance as possible to understand what's expected. We will use technology as much as possible and host events like this, and we can have other meetings, to help folks walk through the registration process, much like Laura did this morning. We want to be there as cooperatively and open as possible is I think the best answer I can give at this point, Justin, to help get the word out and walk folks through that initial process.
And if I may, Steve, Michael Strawn, Compliance Division. So it's a very good question, and we certainly want to make sure that we're being transparent and we're communicating with the industry. From all the things you've heard today from our licensing team that is developing a demonstration, is looking to get people involved when the licensing system's on board. We want to encourage y'all to be a part of that. There's been a lot of behind the scenes action that we've been taking, developing programs, writing rules, everything else. One of the things that you will see in one of our major outlets to contact you all is we always ask people to sign up for our Gov Delivery, our listserv system on our website. We get potentially thousands of licensees or people that are out there. And as the program develops, we put news updates onto our website, but we also send notifications out through that listserv and those updates. Additionally, one of the things that we're doing here at the department is we have been allotted a position, which will be our EV liaison. That individual, when they're hired, will be a direct conduit for you all to ask questions, for them to get involved with the industry, to make sure that we're constantly staying on top of outreach, updates, and everything else in between. So that will be something that will be coming to you all as well to make sure that we are conveying those changes to you. What you heard Steve talking about just now is we're not trying to play a gotcha game. We want to get out there. We're feeling out this new technology, learning with you all as we go. We've had some great meetings with stakeholders as we prepared for all of this, and they've helped us really open our eyes. I think you'll see a little bit later some of that feedback incorporated into the rules when Mark is going to display that. But that's a core function that we want to make sure that we're doing. So our plan moving forward is as we have information, as things begin to develop and solidify here shortly, you're going to see those outreach things more and more often. In its infancy, sometimes there's a lot of figuring out things so that we can't necessarily release information because we don't know necessarily which way it's going to go. When we're looking for technology, when we're looking at what exists out there, standards across everywhere, we can't release something and say it is going to be exactly this way potentially 8 months before we're ready for release. But here as we're coming up, we know what the system is going to look like. We know what these rules are going to solidify into here shortly. Those we will absolutely make sure we're conveying to you, and certainly any changes that we have in the future. I think what Steve was saying earlier, we're developing a partnership here. We have rules out, measures out till 2028, 2030 for us to all work together. And we're going to continue to foster that relationship, communicate with you all, and we hope that y'all be able to communicate with us as well.
Thanks, Ford. Mark, did you want to add anything to this part?
Yes, I would. For the record, Mark Gladney, Assistant General Counsel. I had probably a question and a comment. The question was for John Medlock. John, would you describe the enforcement process that we have here at TDLR as somewhat of a collaborative process with with someone who might be the subject of an investigation? If we receive a complaint in this program, would you describe it as something that is collaborative and not necessarily something that might be akin to an ambush type of thing? We received public comments that seem to suggest that kind of concern, and I just kind of wanted to have you give some clarification as to how the process goes from complaint, on just a brief thing. I know you went into it to some degree, but I think I'm more concerned about the work group knowing whether or not it's a collaborative process.
Yeah, certainly. Typically, I would describe it as collaborative in the sense that we give the respondent every opportunity to tell their side of the story, give us all the information. We do try to work towards, my goal here is more compliance based in the sense that I would recognize that most times these disagreements are not a function of willful intent to harm someone or defraud someone. It's more of a just, a lot of times it's a misunderstanding. So we do work with the respondents lots of times. We do have all of our complaint statistics online for every one of our programs, and you guys will be included in that once we start getting some of those statistics developed. You can always just go on there and kind of see where we are in terms of complaints open. And that's some of the things you'll see in your report. But typically, the prosecutors here will reach out and try to work with and try to find solutions. Now, that's not always going to result in a compromised solution. Sometimes it is going to result in the fact that there will be some violations that will be the subject to some penalties and occasionally some license sanctions. But to Mark's point, we do try to work to find common ground and solutions as best we can through our informal resolution process. And I think we're very successful in that regard. Last fiscal year, we returned over $400,000 back into Texans' pockets. Those were cases that didn't get filed either at SOA or the result of an agreed order. Those were just cases that my prosecutors helped return the money back and find creative solutions for both parties.
And also, my comment is to Mr. Donahue's point on willful destruction of EVSE property. And the other folks are correct that neither SB 1001 nor SB 1732 have that component in it that directly addresses that particular type of behavior. That would be in the penal code and classified most likely as a felony criminal mischief. And it would be more than likely the responsibility of the provider to report, such an instance. And then, of course, law enforcement officials would do their investigation and move forward accordingly. But it is a very big concern and certainly something that, we here at TDLR take seriously, and certainly law enforcement as well.
Thank you. Yeah.
Thanks, Mark. Any other questions or comments for Mr. Medlock regarding the enforcement process? Okay. Well, thank you very much. Then Mark, I'm going to turn it over to you and let's get into some discussion about some of the feedback and some of the proposals for the draft rules.
Okay, thank you very much. Again, for the record, my name is Mark Gladney, Assistant General Counsel for the EVS program. Before I get started on the proposed rules, again, I'd like to appreciate and staff appreciates all the comments that we've received. We received comments from over 16 interested parties with regard to the proposed rules. And staff paid attention to each and every one of them, which is our normal practice in all of our programs whenever we're doing a rulemaking. We're here to discuss the changes that we made pursuant to the public comments that we received. And here at TDLR, we're all about negotiated rulemaking, and further changes could possibly be made as a result of today's discussion. This is your opportunity to let us know how we can best address your concerns, as well as those of the public who own EVs and the general motorists who will use our roadways, so that we can address the balance between efficient EVSE deployment and its reliable use in public safety. As has been said, you are the subject matter experts in this new program, and we are and have been interested in your input. There may or may not be more changes today, some of which we can do if you propose them, and some of them we cannot. We'll certainly provide reasons either way, but we invite free dialogue today during the rulemaking process as we have in our other programs. Now, we're on target for commission consideration for adoption of these proposed rules on October 23rd. so we can meet our SB 1001 deadline of December 1st of 2024. And that also happens to be our go live date for the registration process that Laura Hernandez had discussed earlier in her presentation. And then ultimately, in accordance with SB 1001, the registration deadline actually starts on March 1st of 2025. So lastly, the proposed rule chapter is just simply the beginning of the beginning. We expect that we will be making further amendments to this rule chapter as directed by the legislature, and as the department becomes more and more familiar with the nuances of this program. Staff will be available to you and the public to address any concerns or suggestions that you may have as we move forward into this new transportation mode of the future for our state. So with that, I'm going to try to share screen with you. And you already have a copy of the proposed rules, but I'm going to share screen here, and hopefully this will work for us. Let's see. Is that working? Can you see my screen?
No.
Not yet, Mark.
Okay, I'm still working on it here. Let's see. And it does not seem to want to do it.
Mark, I have a copy of it that I can bring up.
All right, I might be pushing the wrong button. Let me try one more time. And it turns out I did push the wrong button. Okay. Gotta love technology. Okay, can you all see the screen? Okay. Is it large enough for you, or do I need to make it larger?
It looks
I
good.
think it could go a touch larger, Mark, if you can.
Okay, let's see here. How's that? Maybe I could make it a little larger. How was that?
Is everyone okay? You've also, this was given out to you as well in advance of the meeting. But yes, that's looking good, Mark. Thank you.
Okay. See, I'm gonna do. Okay, here we go. Okay, basically the plan is to go subchapter by subchapter and discuss the changes that that staff made pursuant to the comments that we received.
Mark, excuse me, before you get started, can you just scooch down a tiny touch for those who may not be familiar with the tracking system to show that the double underlined and the double striked?
Oh, here we go.
There you go. Thank you, sir. Thank you.
Okay. Yeah, in regards to that, if you see red double underlined text, that is proposed new language that we put into the proposed rules after publication. Anything that's a double strike through is proposed deleted language post publication. So, having said that, we are in subchapter A, which are the general provisions. And I am going to move into the areas in which we made changes in subchapter A, starting with 96.14 entitled Effective Dates for Electric Vehicle Supply Equipment Compliance. Okay.
Hey, Mark, this is Justin with ChargePoint. I guess I just, as we're going through this, I realize you didn't make any changes to the definition section. Did you receive any comments that suggested changes to the definition section that you did not incorporate?
Yes, I did, and I will get to that in a couple of minutes. We'll stay in subchapter A, but don't worry, we'll get to 9610 in a few minutes. But before we do, does the presiding officer have any comments about 96.14 before we move forward?
Thanks, Mark. I did just want to share some high level thoughts regarding the particular provisions. We did hear a lot, and again, thank you for your comments. We heard a lot about legacy chargers. And Mark's going to get into specifics, but I just wanted to share that it's not our intent, and it never was, to have them registered on day one and then immediately come into compliance with manufacturer recommendations. We see those as two very separate steps in SB 1001. I've been with TDLR a total of 12 years, not consecutively. We've implemented a bunch of new programs, and we've added new requirements to existing programs. And as I said earlier, our historic approach, and that's what we plan to do here, is to work closely with you and help you understand what you're expected to comply with before we begin enforcing that compliance. So again, Mark's going to get into the specifics, but we are not interested in having especially for the legacy chargers, having them registered and then immediately go after them for compliance or non-compliance with manufacturer recommendations. So Mark, can you speak to that, please?
Yes, and I'll put the rules back up there. Okay.
Go ahead, Brian, I see your hand up while Mark's.
Sure. No, thank you for your remarks, Steve, about, kind of, let's get the program started. We're going to have a transition period. We're not coming out to enforce on day one. That's very welcome, I'm sure, by everybody. One of the things I think may be something for the department to consider is to kind of put out a policy statement or technical memo or memorandum in that regard, so that people, one, take it serious. They don't hide from it, put their head in the sand because, I missed the date. I'm just not going to do it. It lets them know that there's this amnesty period in play. And I defer to you on what that would be, what that length would be. That's appropriate.
Well, I appreciate that suggestion, Brian, and we're going to take that suggestion. I don't know. I can't tell you what that's going to look like right now.
Yeah.
But I can tell you that as we develop the rules, and especially after the commission adopts an initial set of rules, we will begin work on that, and we'll continue to work with this work group so that we can help get that message out.
Yeah, and I'll kind of try and spot other instances where that may be an appropriate approach for some of these other technical issues as well.
Okay, great.
All right.
Thanks for that. Appreciate it.
You bet.
And this is Mark Gladney. And along those lines, Mr. Moran, I think that kind of goes hand in hand to some degree with the development of an enforcement plan, in which some of the members of this work group may end up working in tandem with enforcement and possibly GC in the development of the enforcement plan. So. And again, the purpose of that is to try to have uniform manners of penalty if necessary, and simply how to handle those situations. In addition, there will be an adoption preamble which will have some commentary related to both the public comments that we've received in relation to these rule sections, as well as just describing what the intent of the rules are, with regard to those rule sections that may not be immediately self-evident in their meaning. So getting to the 9614 and kind of building on what Steve Bruno has said. We did receive quite a few comments related to the dates for operational compliance for EVSE. And to that end, we did make some changes, as you can see on the screen. One of the first changes that we made is we kind of rearranged a few things, and we moved we moved some language in the previous subchapter A, pursuant to a comment, and put that in a later section, I believe 96.20, because that language was more akin to registration than it was the operational compliance aspect of the subsection. So we moved that. And in response to the comments that we got and the grave concerns that a lot of commenters had about how we were setting the deadlines for operational compliance for legacy equipment, as you can see, we extended the date for operational compliance for any charging units that have been installed prior to March 1st of 2025. Or if they were a legacy charger. So having said that, instead of operational compliance being required on March 1st of 2025 for the legacy equipment, it is now March 1st, 2028, and gives some additional time, as was requested in the public comments that we received. So you can see that in subsection A of 96.14. Okay. Any charging units that are installed after March 1st of 2025, then they are expected to be in operational compliance with the manufacturer specifications, the code, and the chapter when they become operational on the provider's digital network. So those were the major changes that we made within 96.14. Okay. Any questions or comments that you may have with regard to the changes that we made in 96.14? Okay, hearing none, then we are going to
Sorry,
move.
I have my hand up. This is Francesca from Tesla.
Oh, okay. Didn't see the hand. Go ahead.
No worries. Two questions. One is, why did you guys add on the provider's digital network?
Because that is language that's taken from the statute, and we wanted to be clear as to when that was going to start. There was a comment from CPS Energy, and they were asking basically, when is a charging unit considered to be operational? So when it was staff's view that a charging unit would become operational once it was activated by the provider on their digital network.
Okay. It doesn't make a ton of sense to me in practice, but sure, I'll take it. The second question was, we as an industry put in comments on legacy equipment, and we pointed to a lot of different places and how this has been treated. So certainly appreciate the removing the sort of in-between period for those chargers installed between 2023 and 2025. But I guess one question we have is, a lot of states have taken the approach that legacy equipment is going to get a 10-year grace period. And so in developing a enforcement plan, is there still an opportunity for TDLR to provide additional justification, given that there's, the broad kind of exemption language, if it doesn't make economic sense to sort of drive enforcement based on one of the sections below? Is that something that could be articulated in the deployment plan, or is it, because it's not written into these rules, like after March 1st, 2028, everything in the ground, no matter when, has to be in compliance with whatever the rules are, which still is not entirely sure what that actually means.
Mm-hmm. And we did recognize that there were some providers that had asked for a 10-year extension. Staff had considered that, and we kind of thought that 10 years might be a little bit on the long side. So we extended it some additional years to 2028. There is a provision, as you said, in Chapter 2311 of the Occupations Code, which allows for exemptions, and that's certainly something that staff has discussed. And as you'll see later on in the rules presentation, we did include the language that is in the statute. We put it in the rule to emphasize that we do recognize that there may be situations that come up in which exemptions, which could involve an extension of time, could be considered. And I don't want to speak for enforcement and how that would fit in the enforcement plan, but it is a part of the rules and the statute. So exemptions, are certainly on the table.
Yeah, and I just want to reiterate, I mean, the letter that we put in as an industry, we represent all of the major charging operators in the state. So that viewpoint is shared by everyone that is a major operator in the state. And I will just say, reiterating, I've said this many times on this call, infrastructure that was put in the ground with any rules in place, having to later on comply with something that is an unknown, will cause an economic burden on those companies depending on what it is, right? And so even it doesn't matter what the date is, you may have to do retrofits. And so there's going to be trade-offs. People may just decide to shut those stations down. And so I do think, taking a closer look at the impact of infrastructure and not penalizing it because it was installed before rules were in place, and using some of those clauses that were put into the legislation in order to make sure you're not being penalized in such a way is going to be important later on. So yeah, I would just want to reiterate that, and make sure that's being taken into consideration. And I certainly appreciate, again, the position you all are in, but I think we've also kind of made loud and clear where we're coming from an industry perspective.
And staff is certainly aware of the concerns, and there may be some flexibility built into this subsection A of 9614 and the date March 1st, 2028. There may be some room for flexibility. Ford, do you have any comments on that?
I don't have anything else to add over what you just provided at this time, Mark.
Mm-hmm. So, staff will continue to discuss that. And, as I said, right now, March 1st, 2028, is the extended date, but it's possible that could get extended, whether it be through the exemption process that's laid out in the statute itself, or in the rules. And I believe that might be in 96.30, but we haven't gotten there yet. So that's kind of where we're at right now. There was another hand up.
Yeah, this is Justin with ChargePoint. So I'll just ditto, I think, everything that Francesca noted. I guess I would just put in plain terms, somebody bought a charging station today, not knowing these requirements are in place. I don't know who that was. I don't know where it's going to be installed. And I don't know if who they bought it from is tracking this rulemaking and is committed to staying in the state through 2028 and is going to be able to service that charging station. And so I think it's a very real issue when people are making capital investments, sometimes quite large capital investments, and regulations require a change that may be dependent upon a hardware provider, a software provider, multiple parties. So just want to ditto that and just articulate that until these go into effect, we kind of don't know exactly what the ramifications are going to be. And 3.5 years for a capital investment is a pretty tough depreciation in most instances.
Mm-hmm. Mm-hmm. Okay. All right, and staff will go back and we're taking notes on what it is that you're saying, and there may be some adjustment to that particular provision as far as the date is in 96.14A1. And we certainly appreciate what you're saying. Okay. Backing up.
Just real quick, thanks for that. We hear where you're coming from.
Backing up, ChargePoint had some interest in the definitions, and I believe which definition it is that they are referring to may be the use of the term charging unit. But I don't want to make any premature assumptions here. ChargePoint, did you have a particular definition that you were curious about?
No, I just think the board, we don't necessarily know what comments you received, what has been incorporated and what hasn't. So I just wanted to go through section by section and understand if, you guys received comments that just were not incorporated.
Okay.
And that the board could voice some opinion on. That was the comment overall.
Okay, and staff can address that. We did get a number of comments related to the use of the term charging unit and the definition. The comments that we received generally centered on the fact that charging unit is not necessarily a term that's commonly used within the industry. And the commenters had said that, and that they thought it might be a bit confusing to use that. We declined to make the change and add what was suggested, which was definition for charging connector and one for combined charging system. The reason why we declined was that in SB 1001, the term charging unit is used in two statutory areas. It is our position, here at the department, that we try to adhere to what the legislative bill, the language that the bill uses. And in this particular instance, the legislature was pretty clear about using the term charging unit, not once, but twice. So we decided to stick with the term charging unit, and you'll find it throughout the rule chapter. I believe it's used about 33 times. We declined to make that change at this particular time. One of the things that I think that staff had thought from the comments that we received, that in some way we were treating charging unit as some sort of different element of EVSE, and that is not necessarily the case. It's not the case at all. And we view charging unit is simply one element of the electric vehicle supply equipment cycle, in which there's a plethora of components that are used to deliver electrical energy to an electric vehicle. So I don't know if that is the main concern here, but charging unit and EVSE, it's all synonymous. They're all part of the same. So if that's the concern, I hope that I've addressed it with that explanation. But at this particular time, staff's not necessarily ready to change the term charging unit, absent some substantive reasons to do so. Okay, and then we also received a comment.
Hang on, Mark. Francesca, did you want to jump in?
Yeah, I mean, I just wanted to say, as an industry, again, we comment on this, and EVSE is the standard definition that you use normally. SB 1001 doesn't define charging unit, and so our simple approach would be that you would have just replaced within the statute the term charging unit within what you guys have outlined here in your draft rules, using the term charging unit, removing that, and just plugging in EVSE, because that's the standardized definition. The other concern that was articulated in the letter, and I think some other entities as well, is that one thing folks wanted to make crystal clear is that, just because you have two connectors on a device, those aren't considered two separate charging unit, and thereby you have to register them each individually and have to pay double fees. I think that was the other concern. But again, it's just not a standardized industry term, and so we're somewhat redundant in having 1 and 6 in there.
Mm-hmm. And I certainly understand that. And when we get to the fee section in 9680, there'll be a discussion about, you know, how we basically calculated fees and how they are basically there's a fee per charging connector on the unit if there's more than one, and we'll go through that. But you know, we do have an obligation, you know, legal obligation to comply with, you know, what is in the bills that the legislature passes, and charging unit is what the legislature decided that they wanted to use. And if you look at the definition a little farther down, number 6 for EVSE, this is a statutory definition. It's a device or equipment used to dispense electrical energy to an electric vehicle. And the charging unit is basically a device that's used as a subset of EVSE, but it's a device that's used to dispense the energy to an EV. And that's kind of the way that we were looking at it. There was also a comment about replacing the definition, or at least making a slight adjustment to number 8, legacy charger. What we have down there right now is an electric vehicle supply device defined in 23110207 of the code. There was a public comment that just wanted us to replace the word device with the equipment. And, you know, I mean, we could do that if we wanted to. I mean, the legacy charger is an electric vehicle supply equipment device, just like a charging unit. So we could do that if so inclined, you know. So if the work group would want us to do that, then we could do that. You know, it's not a big change. Okay.
Well, Mark, just from the industry comments, I think the change was not necessarily just changing that. It was being very specific in the rules. And I know that you're referencing the code here, but being very specific in the rules. And so when people read them, they understand that that's a device installed before January 1st, 2024. They don't have to go back to the statute. They don't have to make an interpretation on what that means. So I just wanted to flag that it wasn't necessarily just, changing the word device to equipment. It's also kind of adding in the date to be very prescriptive about what that is at the end of the day.
Okay. And one thing that we try not to do, although we're not always successful in doing this, is that we try not to mimic statute if we don't have to. In this particular rule chapter, we did more than I probably like to do, but we did. But it's expected from all of our licensees and registrants to not just know the rules, but to know the statutes as well. So we expect our registrants and our licensees to be familiar with both the rules and the statutes. So that's probably why we didn't necessarily go that route. Folks can look at 23110207, but if that's what we may need to do, it's something that staff can talk about after this meeting, and we can add it in there or not. But I just wanted to give you an explanation as to why we didn't necessarily do it in that particular instance. We have another hand up. Is there another hand up?
Yeah, I
Yes.
think it's Brian. We may have a little trouble hearing you, Brian.
Can you hear me now?
Sure can.
Okay, great.
Yep.
Mark, just wanted to appeal as a former regulator where expectations of the regulated entity understanding the regulations, let alone the statute as well, is you may have higher expectations than what really is going to happen. And I would encourage mimicry of the statutory language is fairly common. I appreciate your desire for brevity, but I think particularly with a new program like this, I think including direct references or direct language defining various terms is more than appropriate at this stage in the game. And I guess I would also, on the other issue about the term connector being added and charging unit being perhaps redefined to be EVSE equipment, I'd also suggest that change be reconsidered.
And Brian, I hear you. I just want to make sure that we're sort of talking from the same page. From our point of view, with EVSE and with charging unit, we think we really were trying to copy what the statute had. Now, I understand the statute might not speak the same way that the industry does, but that is what we wanted to lean on. There was the statutory as much as possible for those definitions we got comment on. And I don't want to belabor this, but I do want to keep talking about it a little bit because I'm do you see where I'm coming from?
Yeah, and I guess I mean it'd be one thing if the charging unit was a defined term in the statute. I don't believe it is. So that gives you flexibility to correlate that to industry accepted terminology.
Do you have some industry accepted terminology that could be used to define charging unit?
I don't, but I'm sure my colleagues on the call do.
Well, we would certainly accept any industry accepted definition related to the term charging unit that you could submit to us as quickly as possible. And we'll take a look at it and consider it. However, again, charging unit is a term that the legislature mandated in two statutory provisions in Chapter 2311, and we are pretty much bound to stick to what the legislature has put in the statute when we see not that much wiggle room. Yeah, and I'm referring specifically to 2311-0302 when it talks about required registration. And it basically says, unless the EVSE is exempt, EVSE providers shall register each charging unit of EVSE operated by the provider, and so on and so on.
And just say that doesn't make any sense the way it's written. EVSE is the device or the equipment, unless the intent was to say you have to register each individual port, which again doesn't make sense because it's the same unit and you can dispense power out of two ports, but just because you have two ports, it's one individual unit. You have 3 connectors on the device or 3 ports, whatever it might be. And so that's why we were saying, like, if you read the definitions together, it reads really weird because you're saying each unit of a device or equipment used to dispense electrical energy to an EV. And there is only one. It is one device. The meter is in one device. You don't have 2 separate meters for each port, essentially. So, like, if you think about how charging equipment operates, this is where this breaks down in practice, which is why our suggestion was just to use the term EVSE because that is defined in statute. And if you look at the second part in 1001 where this is used, this term, it just says, remove the EVSE supply equipment that poses a safety risk from the electric vehicle supply provider's digital network listing of available charging units. I mean, these are it's simple language. So I still don't understand why you guys feel so strongly that this term charging unit has such a big implication when the rest of the statute is based on the definition of EVSC.
Okay, well, as I said, if you all have some language that you would like to see us consider, we're all ears, and staff can talk about it. But we would need the proposed language submitted pretty quickly. Okay.
And I'm not gonna put you on the spot, Francesca. I know you and others commented on this. I don't know if I missed it. Did you have a recommendation in your comments? And we can get together after this.
Yeah, our recommendation was just to remove the term charging unit and use
Yeah.
the term EVSC.
And I
use
hear
that
you.
throughout. Justin just put something in the chat, which is another way to do it, which is, you refer back to charging unit and EVSC being the same thing, essentially.
Okay, I missed that, Justin. I'm sorry if I shared something. Do you?
Yeah, I didn't see that either.
Oh, it's in the
It's
chat.
in the-
It just, electric charging unit dash the electric vehicle supply equipment. They're one and the same. I think that's.
But even at that, I mean, is the intent that we register every port?
No,
On
just
the unit?
just the unit itself.
So I can have if I buy a big power cabinet and I have 8 ports, then I'm only having to register that one unit that has 8 ports.
Well, we are currently charging per port, though.
So I think this is where there again is confusion of how charging stations are set up and what is we have power cabinets that do nothing, and we have the posts, which are fed by the power cabinets, which have the meter, and that is the unit that you are regulating.
Well, that's my
power
point.
cabinets
Is
are
like
not
I
that.
can get a Mitsubishi power cabinet that has 8 ports on it.
Yeah, but an EVSE is the post that we're talking about that you're regulating in that definition.
But that
Because it is
post
doing
could
the
have
dispensing.
But that post could have two ports on it.
Right, which is totally fine, right? Because that's
So we register. So you're not registering each port. You're just registering the post. So it's cheaper. It'd be cheap. So if I put in a bunch of singles, then I'm having to register all the single ports. But if I put in duals, then I have half the registration.
Yeah, we don't have dual connectors on our stations.
Well, but we do. Yeah.
Right. So I'm saying you should pay the same as us. Otherwise you pay double. You pay. Why would you pay more?
So it's definitely, we're better off putting in dual port units.
If you wanted to, yeah, it depends on how you set up your system and split power and do things like that.
Mm-hmm. Because then you're less registration. I mean, it's so vague that you fight it either way.
Okay.
See, when we list our charging on our networks, it's always by port. It's every port is its own unit because that port can charge a car by itself. Now, if you have a charging station with 2 hoses but can only charge 1 car at a time, that would be considered one charger. But if I have a EVSE that can charge 2 cars at once or 8 cars at once, all of those ports would be considered separate on our network.
I agree with everything that's being said here, and I think we're going to talk about this later on the fee section. We're kind of getting ahead of ourselves, but I think this will become apparent when we get to that section. But I just want to say that I second what these folks are saying. There's confusion about this, and I think we need to settle it.
Okay. Now let me ask a question. If you have a charging station that has multiple ports, say 3 or 4, that one charging unit would have one ID number, would it not?
Depends how many cars it can charge at once. If it can charge 2 cars at once, it would have 2 ID numbers, one for each port.
Okay.
If it can only charge 1 car at a time, then it's 1 ID number.
Okay. All right, those sections that I discussed were the ones that we got most of the comments on in 9610. Are there any more comments or questions related to 9610 before we move on?
I just want to make sure that we have captured Justin's note.
And I can't see that note, so
Okay.
somebody else is going to need to capture
Jeff-
that note.
Steve, this is Ford. As this is recorded, we should be able to retain that through the recording at the very least, but if not, I'm
happy to send a note. I'll put it in an email right now, Mark.
Okay, I
Yeah.
appreciate it.
Thanks, Justin.
Okay. Okay. All right, then moving on, we're going to subchapter B. This is a change that was suggested by a commenter, where we originally had this language that's double underlined in subsection A that used to be here in 9614. It was determined that it was more appropriate to have it in the registration section. So we put it down here in 9620 regarding registration. So we put it there. Are there any questions or comments related to that particular change? Okay, then moving on. Okay, here in 96.21, we had a comment, I believe it was from CPS Energy. They were concerned about chargers that were installed prior to March 1st of 2025 as to whether or not they had to submit a statement that the charging unit was installed by a licensed electrical contractor. You know, obviously those charging stations are already in the ground. They may or may not have been, and they were concerned about that legacy equipment is it going to are they going to be able to have to do that, because that could be a problem. So we added this extra language in here so that any charging units installed on or after March 1st of 2025, then yes, that statement saying that licensed electrical contractor installed the unit, the installation was performed within manufacturer specs, and that the charging unit was in proper working order at the time of installation. Yeah, those are required for any charging units that are installed on or after March 1st. Okay, so that's the change that we made there.
Does that mean
Mark,
does that mean a general contractor that has a certified electrician isn't qualified?
Who asked that question?
George Johnson.
Okay. In chapter 2311, it states that EVSE that's installed and operated has to be done in accordance with the electricians chapter 1305, and a electrical contractor, for want of a better description, is kind of the business entity under which the classes of electricians operate. So the master electricians, the journeymen, and the apprentices would operate under a licensed electrical contractor, and that entity, provides the insurance that's necessary, both liability, workers' comp, that kind of stuff. And they would operate under that umbrella, and that's required under 1305 of the Occupations Code.
So as a general contractor, I can hire an electrical contractor, but I can't hire a master electrician to do it.
Well, that's essentially the same thing. This is Steve Bruno with TDLR. Real quick, you're the electrical contractor. It actually happens to be another program that we license. So that's the business entity that you hire. So if you were a contractor, or if you were just a company or whoever, and you needed to have electrical equipment installed, you would hire someone who has an electrical contractor license.
Gotcha. Okay.
Does that make sense? Okay.
It does, because as a general contractor, I'm building charging stations, but I hire electrical
Sure.
contractors and.
Okay. And the
Steve,
reason
Steve,
There's
can I-
another, we got another
Yeah.
hand on that, Mark, real quick.
we got a hand
yeah,
up.
can I, yeah, can I
Jeff.
ask a follow-up, Steve? So Steve, let's say I'm a municipality or a school district. I can employ a licensed electrician without being an electrical contractor, correct?
Justin, I want to make sure I get that right. I don't want to answer that right now.
Okay. Well,
for fear of messing up. But
maybe I'll make.
if you're a school district, I can say this. Let's say you're a school district and you're going to be installing something electrical. You know, you're building a new school or you're rehabbing a school. There's going to be a licensed electrical contractor involved, per the electrician law. There is a whole list of exemptions to the electrician statute, but you know, a school district or something's not one of them. So I want to get back to you on the specifics of your question. So I don't know if I helped or not with that response.
Yeah, I guess I would say
we're
that
not asking. We're not saying that your company has to become an electrical
Yeah.
contract.
Yeah, no, yeah,
Okay.
yeah, completely understand that, but I do. So, and this is a nuance of Texas that I'm certainly not familiar with, but I'll just make my comment.
Okay.
I would want any entity that like already employs an electrician or a master electrician to be able to install an electric vehicle charging station. There's no difference in installing an electric vehicle charging station and under many normal circumstances that requires anything more than just being an electrician. And if a school district or somebody like that is already employing electricians, they should be able to utilize those that they have on staff rather than contracting out, in my opinion.
I understand, Justin, and that's why I was hesitant to give you specifics, and I'm not going to give you specifics now, but it under the electrician statute.
T. Bruno, can you hear me? This is Larry.
Larry, I can hear you now. Yeah, I didn't know you were here. I'm sorry about that.
That's okay. I'm driving back from Bryan College Station.
Would you like to jump in? And
my-
I'll go on mute. Thanks, Larry.
Yeah, so my name is Larry Rockel. I'm the Chief Electrical Inspector for TDLR, and I cover the electrical program in Chapter 1305. And when we're talking about public entities like the school district, you're looking down there towards, I believe it's G, or and again, I'm driving, but right under there, it says that doesn't allow them to do it without the proper license. So if a school district has a master electrician on board, then they can perform new electrical installation. If all they have is a maintenance electrician or a journeyman electrician, then they cannot perform their own electrical work, because even though they don't have to have the contractor license to show insurance since they're self-insured, it still does not allow them for a maintenance electrician or just a journeyman to do the work. It would have to be a master electrician employed by the school. And that goes for any public entity. And then all the other ones underneath that master would have to be appropriately licensed at the minimum of an apprentice. Does that answer your question, sir?
Yeah, I think it does. And so, I mean, and again, I'll take a look at, what is it, 1305 a little bit more. But to me, then master electrician becomes kind of your lowest common denominator rather than the electrical contractor, at least in my mind, but I'll take a look at it. And that's what I wanted to do. These level 2 charging stations, there's going to be a lot of entities that have electricians or master electricians on staff, and they should be able to do that without having to contract with a third party, in my opinion.
And we're talking about public entities like school districts and stuff like that, right?
And well, it could be. Justin, I think I understand your comment a little bit better, and we will continue to work with you and of course everybody outside of the meeting. But as you get a little bit more into 1305 in the electrician statute, let's continue talking, because as you'll see, there are some provisions in that statute that I want to make sure folks understand. So thank you for that.
And this is Mark Gladney. I think that one of the reasons why we were moving toward the licensed electrical contractor, there was a comment that was submitted by a commenter about the idea of allowing journeyman apprentices with some special education, special training to install these units. And it may be in the NEVI rules. I have to go back and check, but it was certainly something that we staff was having some consternation about. And since the installation, the operation in the chapter 2311 referred back to 1305, we thought it was more prudent to require it be a licensed electrical contractor. So, any other questions or comments related to that subsection? We did make one additional change to 96.21 C, and we added in, if there was a change in controlling, we added the word controlling provider ownership takes place, then a new application for registration would have to be submitted within a particular amount of time. Now, that was in response to a comment, and I had a slight question as to a thought to possibly removing the word ownership and just leaving it as changing controlling provider, because provider can be an owner or an operator. And if we were to do that, then I was thinking that we might need to put in a definition as to what constitutes a controlling provider. There's something similar in the FMQ rules definition related to controlling provider that we can insert into 96.10 in the event that there needs to be some definition to that term. And I think that there may need to be a definition inserted in 96.10. And I was kind of wondering what y'all thought about that. Are there any thoughts related to that idea?
I think based on the comments, we wanted to make this less onerous. Are we heading in that direction?
Yes, that was the purpose for that, because the comment that we received, the commenter was thinking that if there was any kind of change in ownership, that a new registration application would have to be submitted, and that's not our intent. So if y'all are fine with that particular language, then we won't necessarily add any kind of definition in 9610 to address controlling provider.
I think that works.
Okay. What about removing the word ownership and just leaving it controlling provider? Okay, if I don't hear any objection to it, then that's what I'm going to do then. There's a hand up.
Yeah, just wanted to clarify under, the operating code, under NEVI, a lot of the states are allowing like a electrician certified to install electrical vehicle equipment. And that may not be a master electrician. And here, Texas is being more stringent than the federal government in terms of its requirements, where you're requiring, a master electrician under the purview of the master electrician.
Well, Brian, really, from our perspective, we're this statute, the EV charging statute, directs us to rely on the electrician statute as well. And basically, except for some exemptions that Larry discussed earlier, and that are listed in the electrician statute, if you are installing electrical equipment in Texas, it needs to be installed by an electrical contractor. That's sort of what was in place before this program was born and came along. And we can certainly work with you and provide input on any possible changes the industry may want to seek to the statute in the future. But from the department's perspective, what we're balancing is that reference to the electrician statute in Texas within this EV statute. And again, it outside of certain exemptions that are listed, the installation of electrical equipment must be done by an electrical contractor.
Yeah,
Today.
I certainly can appreciate that construct.
Okay.
And I think for the majority of at least fast chargers anyway being installed, the funding will likely be, from NEVI.
Yeah. Okay.
And so to anticipate that, this would be
Yes,
a
sir.
remarkable departure from what typically is
Okay.
required.
That is good for us to know.
Yeah.
And I want to, it is definitely an issue we will keep an eye on. And we will continue to work with the industry with, because again, a couple of my high level points from the beginning, if I'm not mistaken, and y'all, I'm relying on y'all, I think we're going to be the 5th state to have rules about this. So we're pretty new into this territory. And we want to work with you, and not find hidden ways to punish you as this industry continues rolling out in Texas. So again, thank you for that. That's really important, I think, for all of us involved in this, not just this rulemaking, but this program, to recognize, and we will have to make sure that we are able to strike a balance between what NEVI's putting out and what the state law is here in Texas.
Right. And maybe there is some flexibility in there that a journeyman over the, with oversight can do this. That's all.
And
Yes,
I
sir.
think that a journeyman that's operating under the umbrella of a electrical contractor probably could.
Well, let's not, Mark, I'm super hesitant to get too deep into the electrician statute in this one.
Mhm.
Okay.
One other thing I would mention is that SB 1001 nor SB 1732 discussed NEVI. The legislature didn't bring that up. So those rules are applied to a slightly different situation than what SB 1001 and 1732 did.
Yeah.
Okay. Moving on.
Mark, real quick,
Yep.
sorry for the interruption. I just wanted to remind everyone if we could refrain from using the chat, because that is not, I believe, recordable or being able to be seen by the public.
Yeah. Additionally, if you have some suggestions that you want to put in the chat, please send the email.
Yeah, sorry, just for transparency, I put in the chat and I'll just notice it. Thanks, Alex. I missed those instructions. I think looking at 1305, so looking at the statute, it says that, essentially electric vehicle charging stations must operate within 1305, right? So broad jurisdiction for what that, means. And I think potentially you could just say electric vehicle charging stations must operate within 1305 and leave it at that. Let organically the businesses who are installing the electric vehicle charging stations determine how they fall under 1305. I think would be one way to look at this. If there is a desire to be more specific about what type of person needs to be able to install these charging stations, I think it's important to understand there's a vast difference between installing a level 2 charging station and installing a DC fast charging station. And, you know, putting those both under the same umbrella might not be wise. From the perspective of installing a level 2 AC charging station, a apprentice, journeyman, master electrician all have. I don't think apprentice is in 1305, but those all have more than more than enough training to install an AC level 2 charging station. Anything else would be overkill, in my perspective. So just for transparency, that was more or less what was in the
And
chat.
Justin, I appreciate that so much. I do, and I'm not certainly not going to disagree with you. I just want to, as oftentimes happens when programs meet, we just need to make sure that everything meshes, and recognize that, you know, some of the statutes were written a while ago, right, and didn't contemplate everything that would be happening. So we just need to. Your points are very well taken, and we need to pay careful attention, and possibly suggest changes where needed, so that things are aligning and not causing any unintended consequences. Because, yeah.
Okay. All right, then moving on, 96.22 on renewals, we made a minor change. We didn't really receive any comments related to that particular section. Okay. And just as an aside, something I mentioned earlier in the meeting, when a renewal is being done by a provider, we like to have a true up of all the active charging units submitted with the renewal application prior to paying the fee. So that's why we don't necessarily have auto renewal at this particular point. That could come later on, but that is kind of an important thing that's been occurring over in the FMQ world, and I think messing with the software a little bit. So that's why we added that particular provision in there. But, you know, again, technology evolves, the software will evolve, and eventually we may get to that point where there's self renewals. Okay. Moving on. 9623, we did receive a comment related to the use of the word retires charging unit in subsection B. It was suggested that we use the word decommission, and we did. So that's a change we made there.
Hey, Mark, just one, I guess one thought in this, you know, again, I'm kind of got my head in the level 2 space, which, you know, is very different than operating a gas station, very different than, you know, a lot of other devices. I guess, and this could be done in interpretation, but I'm curious if essentially just not renewing your registration can serve as notice of decommissioning. Or I guess I am worried about these entities, these coffee shops, these shopping centers where an EVSE, a level 2 AC charging station, is not their primary mode of business. If they decide that, hey, I don't want this electric vehicle charging station, potentially the last thing on their mind is that if I'm taking something away, I need to provide a notice to a regulated department that I am removing that charging station. If I bolt it down, it's safely decommissioned, that's decommissioned. There's really not much additional notice that needs to be provided. So just want to flag that. I think we see stations, you know, removed from our network on a regular basis for a variety of reasons. And I don't think that providing notice to an agency is going to be at the top of the mind of an entity that's selling a building or, you know, decides to just remove those stations. So what that's worth.
Okay. Yeah, that's noted, and we'll take a look at that. All right. Okay. 9624, we received a comment on that. Basically, they wanted us to use the term provider as opposed to registrant, which makes sense. So we use the word provider pretty much throughout the entire rule chapter. So we made that particular change. As you can see, there was some question raised by a commenter about they seem to interpret that rule as if a member of the public requested a copy of the current registration, that they would have to do both the electronic link, refer them to electronic link on their digital network, and provide a copy of the certificate to the requester. That was not the case. It's an or. The provider can decide how they want to comply with this. We're not entirely sure yet whether or not a hard copy will be issued as a certificate of registration, at least the first go round. We may do it if the first time, and then after that, if somebody say loses the certificate, they can always download it, probably self-serve through the Versa application. That's still in talks, unless Laura, if you're still on, you can clarify that. And she may no longer be on, but in any case, it's an either or. Again, leave it to the provider to determine how they're going to provide their certificate of registration to someone who asks for it. That's all. Any comments on that one? Okay, moving on to exemptions. As you can see, we added in the statutory language in the statutory chapter for exemptions. And this was brought up by several commenters with regard to whether or not certain aspects of of our rules or the statute can be exempted. So we wanted to make clear that yes, that can certainly happen. We're still probably working through a process, because one of the commenters had expressed an interest in having some type of exemption process that they could apply for an exemption if need be. So we're still, staff is still in the process of discussing how that would be, but it's certainly something that staff could see happening in the future. Was there a hand up?
Yeah, so Mark, thanks for this. I guess I'm glad for that explanation. I was trying to determine how to read this. So to me, there's two ways to potentially read this. One is that the department can essentially create an exemption to portions of this rule that would, be blanket across the industry. The other way to read this is that, a specific piece of equipment or a specific provider could be exempted from portions of this rule. I think you described the latter. Is that correct?
Yeah, and any other member of staff can speak up on this, but when we were talking about this, in response to the comment that we received, the commenter had asked for some kind of variance application process. And that is something that, we think could be done by a provider if something, some situation came up for which they required an exemption, and they could show, it's not feasible with current resources for us to do this, then that may be something that the department could do. Or it could be something sua sponte that the department, has made a determination based on information that's come in, and we discover that some kind of situation has arisen with some frequency that could cause some issues that meet one of those three conditions in subsection A. So it could be actually both. I don't want to overstep my bounds here, but Steve, is that something that sounds reasonable and logical to you?
As we're talking, I'm trying to go through some possible examples in my head. I think that sounds reasonable, Mark.
Yeah.
Just just from an industry perspective, I like it. I think it's great, smart to have in the rule. I would say from an, we view these sorts of regulations as one, to protect consumers, and then two, to provide equity in the market amongst business competitors. And so we would just say, we would want the exemptions to be to any provider to be able to avail themselves of these exemptions if granted to another provider. So whether that's a notice, process, or you can work that out in implementation. Just thought I'd go ahead and flag that.
I think leaving it open to both the department and to an individual provider, is probably some flexibility that may make some sense. So that's kind of what we were thinking. Mr. Moran.
Yeah, the language is applicable only to EVSE equipment, not the provider. So maybe you need to insert may exempt a provider from electric vehicle supply requirement. You see what I'm getting at?
Yeah, I see where you're getting at.
Yeah.
Let me put that. Exempt a. Yeah, I like that. Okay. All right. Any other questions or comments related to 9630 before we move on? Okay, great. Moving on to subsection C. We did get a number of comments related to the inspections and investigations. Enforcement kind of went through with y'all what the process is. I would invite not just the folks on the work group, but everyone who's watching to just go to our chapter 60, subchapter H, which governs the department's process and procedures related to inspections and investigations. And I'd like to point out one thing in particular that we saw in the comments, and there seemed to be a little bit of trepidation as to how investigations and inspections were going to be conducted. First of all, right now at this particular time, the type of inspections that are going to be conducted are going to be more paper related, and as we get to the record keeping section, we'll talk about that a little bit more. But there is no plan at this particular time to do on-site inspections, and the public comments that we were getting seem to be a great concern about the department coming out and doing on-site inspections. Will that happen in the future? Yeah, possibly. The statutory chapter allows the department to have the authority to do on-site inspections, whether we do them ourselves or we contract with a third party. But at this particular time, our inspections are limited to basically record inspections, and our inspections are covered under Chapter 51 for risk-based inspections. So if we get a series of complaints against a provider, then that's going to kick in our risk-based process, and we may end up doing more inspections of that particular provider just because we've gotten a lot more complaints and violations for that particular provider. So that would be what we would be doing with relation to that. But if for chapter 60 and subchapter H, some of the comments were concerned about whether or not there would be a time period to comply with any requests for records due to inspections and investigations, or if an inspection was made and a problem was found, whether or not there would be an opportunity to cure. Well, under our inspection procedures, Rule 60.221 E as in Edward, when you have an inspection, that particular section says that when corrective actions are required, the inspector would provide the license holder a list of required corrective actions and a time period for completing each corrective action. The licensee must complete the corrective actions and provide verification, and the department may grant extensions of time for corrective actions at its discretion. Okay. So there is leeway in Chapter 60, Subchapter H, whether it's inspections or investigations, and that's something that you're going to work out with whether it's the Field Inspections Department, Compliance Division, or the Enforcement Division. But there is leeway and there is opportunity to cure. So those commenters who were, afraid that, oh, hey, we're not going to have an opportunity to fix whatever's found. Nothing could be further from the truth. You will get that opportunity to do so. It's right there in Chapter 60, Subchapter H, and I encourage everyone to take a look at that particular subchapter. Yeah.
Mark, we have a hand up.
Okay.
Yeah, just one comment on this. I think when we as an industry commented here, we also just pointed out, again, legacy equipment, our favorite topic, and the idea that just to make sure there's the recognition that you would not be inspecting legacy equipment that is not subject to any sort of enforcement today. So appreciate you providing the clarification on sort of the idea that inspections are currently limited to the paper side, but I think that was sort of another concern is if you have legacy equipment that's not subject to the rules, that there's not some random inspection that you have to consider of that equipment.
Yeah, as I said, if there was going to be any inspections, it would be limited to paper only. The exemptions, the operational exemptions that are seen in 9614, those are obviously going to deal with any equipment that's been installed prior to March 1st of 2024, or 2025, sorry. So, to that extent, yeah, I guess there'll be some exemptions with regard to that, but not necessarily as far as inspections are concerned. We receive a complaint, we're gonna check it out, but within the framework of Chapter 60, Subchapter H.
Okay, that's helpful. I'll just say again, from a business perspective, that gives people anxiety and uncertainty if you are being inspected for something that you're not subject to, right? And I understand consumer protection is incredibly important, and you need to check out complaints, but I just worry that might have unintended consequences for people who are considering or operating charging infrastructure that are not, the big shops who do this every day, but more of the mom and pops who have one or two chargers who now might get worried that they're going to be subject to inspection. So I think just providing some clarity around when it applies and when it doesn't is useful.
Yeah, and again, it's the entire context. I mean, if you have somebody who's only got one or two chargers, and we do receive a complaint, we are going to look at it, but how it's handled, what the disposition is, and what the problem may be, that's going to be kind of a case by case kind of situation. But again, as we said at the very beginning, we're not going to be hiding behind every rock waiting to pounce on people, for some small problem. And so we're trying not to have you all have that uncertainty, but if we do receive a complaint, we are at least going to take a look at it and possibly act on it. Okay, moving on to subchapter D. If I can find my cursor, there we go. Okay, this is one that we had a lot of comments on, and I think there was a misunderstanding. it was believed that we wanted to have the complaint information provided by the EVSE provider in all three of these manners. So the information about the name, email address, and etc. for the department. The statute says the notification must appear on the charging unit, visual display, or the provider's digital network. Okay, that's what it says. The language that was in here, I think, probably gave the impression, and that was probably because the word "and" was in there, that we wanted it all three ways, and that was not the case. So we made the correction after we were alerted to it by the comments, and it is as you see here, which is consistent, consistent with what's in the statute. And the statutory section is 2311-0304. Okay. Are there any questions or comments related to this change? Okay.
Sorry, I have one. It's Lindsay
Okay.
at UVigo.
Yeah, go ahead.
Yeah, I appreciate you guys making this change. This was a big deal for us, so appreciate that. But I was wondering if you could clarify when providers would have to comply with this. Is it the dates that were in there previously, depending on when you installed the charger, or is it different than that?
Okay, and we did get a question related to that. So, and anybody from staff, correct me if I'm wrong, but 9614, this would be considered kind of an operational exemption. So if it was a legacy equipment device installed prior to March 1st, 2025, then they would not necessarily have to comply with that until 2028. Okay, answer your question?
Yes, thank you very much.
Okay. All right, moving on to 71, consumer information sticker. We did get a number of comments related to this one. There was one commenter that kind of thought that y'all had to provide your own stickers, and no, you don't. We're going to provide the stickers just like we do in FMQ. There was also a comment from Walmart, and they were concerned about if a sticker was damaged or missing, and we got a complaint on it or whatever. How much time would they have to cure the condition? And originally we had 30 days, but Walmart had requested that they wanted 60 days. So we thought, yeah, 60 days, perfectly fine. We're okay with that. So we made the change, as you see. Now, there was a comment that was saying that the provider would have the ability to replace a sticker within 60 days after the department discovered the condition, not the provider. Well, the language that we have proposed in there is that the provider discovers the condition, and they have 60 days in which to contact us for a new sticker. It makes more sense from our standpoint that the provider takes care of their own equipment. Now, certainly y'all have regular, maintenance rotations that you go out there and you check your equipment or repair it, or do just regular maintenance to your equipment. If you happen to find that the sticker is missing or it's damaged beyond being recognizable, then you have 60 days from that particular period of time in order to contact us and replace it. That's staff's view on this, and we think it's reasonable. What are your thoughts on this?
Mark, are you asking the working group members or the staff for the thoughts?
Yeah, the working group members. Yeah.
Okay. Justin from ChargePoint here. So I would, I think I think this is repetitive a little bit. So if you look at, in 9670, you had kind of three options. We talked a little bit about, you thought we misinterpreted it by saying, well, it wasn't all three. Well, now I guess kind of we're down to two, but they're duplicative. what you're requiring in 96.71 is the exact same thing you're requiring in 9670, except rather than on the display or the provider's network, now you're requiring it on a sticker on the station. So I guess, yes, we went from three, requiring this on 3 places down to 2, but at least, our view is it's still, especially for those legacy chargers, that's an effort to go out and put those on there. We can get this done digitally on the network or in a visual display, which is how most people interact with these charging stations, quicker. We can keep it up there. We would view 96.71 as duplicative of 96.70 and would suggest removing that. Or alternatively, you could provide that as an additional option as long as you provide one of the 3. So that's our comment.
Okay, was there another hand up?
Yes. I agree with Justin's thoughts. If you could provide the information to the consumer in whatever form, whether it's on the digital display or sticker, should be acceptable forms of notice about what the consumer's rights are, how to file a complaint, who to contact, all that kind of stuff. So I would agree one or the other approach should work.
Okay. Any other questions or comments related to that? All righty. Well, staff will go back and we'll talk about this. All right. Okay, 9672, we had a comment about this, mainly it was and concerned about the use of the word recall. So as you can see, we removed it. And we removed it mainly because it wasn't necessarily in statute. So we removed it from there. And then there was another comment because people were concerned about the term removed from service as the department requiring the provider to actually physically remove the charging unit from its location if it was damaged. And we wanted to clarify that no, you're not required to relocate any EVSE from its current location while it's under repair. So we hope that that took care of the concerns related to this provision. Are there any questions or comments related to this one? Okay. Okay, record keeping requirements. We did have a couple of comments related to this particular section. Some commenters thought that we were requesting far too much documentation because we were asking for documents related to installation, maintenance, inspection, and calibration of the EVSE. They wanted it limited just to the metering functions. And I believe, let's see. Yeah, I think that was the major issue related to record keeping requirements. Staff kind of declined to make that change because if we receive a complaint, we really don't know what type of complaint that we're going to receive, and it's part of our customer protection aspects to be able to look at all relevant documents related to the EVSE that's complained about, and it may help us determine, what steps, if any, are to be taken next. So we wanted to have all of those documents related to those 4 areas of as mentioned. Now, there was one other comment that was saying that, well, there may be some documents related to these four areas that are not in our care, custody, or control. We understand that. If you don't have that, then under Chapter 60, Subchapter H, if you get a request for documentation to be submitted by a particular period of time, if you're not able to submit certain documents, then you just simply report that to the department and say, well, those aren't in our care, custody, or control. Well, and we will respond accordingly. Well, but we're not going to necessarily, and again, I don't want to speak for compliance or for enforcement, but we're not going to necessarily go and react negatively with regard to that. If you don't have the documents, you don't have the documents. Okay. But you are expected to maintain and preserve the documents that are in your care, custody, and control that relate to those four areas. Any comments or questions? Okay, hearing none. Oh, moving on to the fee section. Okay, I guess we'll have some discussion about this, but Mr. Moran, do you have a comment?
Yeah, just before we leave that, the list of things to keep records of, for 3 years. Do you really need to see every inspection that's done, all the maintenance work, which likely there isn't going to be much maintenance? I'm just trying to figure a way to make this a little not as broad and all encompassing.
I think I think staff was just simply thinking about just the overall, customer protection aspect, and we have no idea what type of complaints that we're going to get with regard to when somebody goes and charges their EV, and in our other programs, we like to have an array of records that we can examine to make determinations as to whether or not this is warrants a further escalation in activity or not. So I think for now, right now, the more documents that we have related to these areas, it probably gives us a better understanding as to the merits of a complaint that comes in. Yeah, that's not to say that we can't adjust later as things go on. As I said at the very beginning, as Mr. Bruno stated, these rules they're going to be amended. Based on what it is we learn as all of us move forward into this somewhat uncertain future. Okay, so if it turns out that we don't need the information in these four discrete areas, and we only need it in certain areas, then we'll make those amendments. But for now, I think casting somewhat of a wide net, because we don't really know what's going to come at us, might be somewhat prudent at this particular time.
And just also to clarify B as well, is that this isn't like on demand at the time of an inspection. You need to produce the records. You can make a request either in person or in writing to say, hey, in 60 days, can you get us this information, or whatever time period you believe is appropriate.
Yeah, you all would work, the provider would work that out with the investigator or the inspector. And as I said, they're reasonable individuals, so you would work it out with them in accordance with Chapter 60, Subchapter H of our rules. Great. Okay. Now, we're going to get to the fees, and I guess there'll be a little discussion on this. As you can see, our fees are charged, initial registration, $30 per charging connector, $25 for renewal, $1 for the information sticker. Those are basically our fees that the department had done a fee study We did an initial fee study when the bill was being drafted, and then we did a subsequent one later. And I don't know if Tony Cavillion is online, but are you?
I'm here, Mark.
Okay.
Thanks,
and
Tony.
Can you give the work group members kind of a brief description as to how we came to those numbers?
Hi, I'm Tony Kuvion. I'm the budget analyst for the department. Initially, the fees were determined at the time during the legislative session when SB 1001 was in the works, and the fees were based on the number of charging units that were anticipated to be registered in Texas during the first 5 years following the passage of the bill. Once we got to the rule part of the figuring the fees, things had changed since last April, and some of the department's expenses had gone up. And so the fee for the initial registration went up slightly to cover those additional expenses. The thought behind the charge per connector is the more connectors you have on a unit, I hope you don't mind me saying unit, the more charges you have, or connectors, I'm sorry, you have on a unit, the more opportunity there is for things to result in calls to the department or complaints to the department for that particular unit. If I could, like an example, if you have 2 locations, one has a charging unit that has 3 connectors, and you have another location where it has 3 units, they have 1 connector. In the first one of the connectors on the unit, you know, the cord is frayed and some wires are exposed. Someone calls in to complain. At the other location, if one unit has a frayed hose and there's a complaint, or there could be a complaint on that. Back to the multi-connector one, the second connector, someone may, you know, they'll look at the first connector and say, oh, that hose is damaged, I'll use this one. And the next one, you know, connector 2, and connector 2 may not be working. So that's a second complaint on this same unit. Meanwhile, over at the one with multiple units, there's only one complaint on the frayed hose or cord, and then there would be a complaint on the second unit where the connector's not working. Then if you want to go to the third connector, you know, the purchaser believes that they didn't get the right amount of electricity, so they file a complaint on that third connector. Meanwhile, at the other place, it's on a third unit where they're complaining about the connector not giving them the proper electricity. So in the first location, we've got 3 complaints on a unit that paid $30. Meanwhile, at the other one, we've got 3 complaints at a place that paid $90. So the possibility arises that you've got a multi-connector unit that's causing more complaints than a single connector unit, and causing the department to expend more resources on that particular unit, there's a difference in overall fees for the 2 locations. I hope that makes sense.
Steve, did you have something that you wanted to add on that?
Well, and Tony, correct me if I'm wrong, but I know that when we initially did our fiscal note, we did have it as a 2-year. And we, as you explained when we're with this implementation.
Correct, sorry. Yeah, I didn't get to that part. Would you like me to talk about that, Steve?
Yeah, if you don't mind.
Right. Well, it was because of the date that the registrations are required being March 1st. What would happen is, you know, 99% of the of the chargers that are going to be registered in March of 2025. And if they have a 2-year license, they won't renew until March of 2027. Meanwhile, there will just be a scattering of additional chargers being registered as they are installed and come online. And so it would there would not be that many of them in 2026. So what would happen is 2025 would have a big chunk of money. 2026 would not have as much. 2027 would have a big chunk of money. 2028 would not have as much. Meanwhile, our expenses for the program are consistent each year, and the fees have to pay for the program. So we would have too much money in one year and too little money in another year. And there was too much difficulty in trying to get this worked out, especially in our licensing system. So we thought it better to just go ahead and do a 1-year license type for 1 year, maybe 2, while we get things squared away. And then we can transition at a time where the revenue will be consistent over the 2-year periods.
Right. And so this is another example for the work group and anyone else where, because this is the initial set of rules, we will always have opportunity, and we will intend to offer a change at the appropriate time to convert this to a 2-year. The fee amount would be the same. Essentially right now, it's about half of what it would be for a 2-year license. And so I do want everyone to know that that is our intention, but because of the registration requirement coming in the middle of the fiscal year and our need to project out on a 2-year, a consistent 2-year budget, that's the reason that today the proposal you see is 1, but again, we do intend to move that to 2.
Steve, I had a question and a comment. Previously, when we were discussing another section, someone had raised the idea of a charging station that could charge multiple vehicles, possibly at the same time, and those stations would have separate ID associated with them. Tony, is that going to have an effect on the initial and renewal registration fees related to those types of chargers?
Mark, I think you're going to have to ask the question in a different way. I'm not sure I understood what you were asking me.
Okay, if you have a charging unit that can charge, say, 6 vehicles, say all 6 at the same time, it was related that each one of those, each one of those plugs, I guess, or it could be considered a separate unit because they have separate ID numbers. Would we consider that one unit but with 6 different IDs, or would that be considered 6 separate charging units? I thought that from staff standpoint, what we were concerned about was making sure that we had, we wanted to make sure we had the IDs down when they were registered, because if we got a complaint, we needed to know which specific charger ID was the one being complained about. But if it's charging 6 different vehicles at one time, but it's one unit, I'm trying to figure out whether or not that's going to make a difference in terms of fees, or are we just going to charge the $30 for initial and then $25 for renewal? Mr. Chamberlain had his hand up. I don't know if he's responding to answer that question or what, but I don't know.
Well, do you want me to respond, or do you want me to wait until after Mr. Chamberlain?
No, go ahead. I'm just waiting. Let's talk about this topic in general.
The fee being applicable to each connector was not related to how many vehicles it could charge at one time. It was just the possibility of department resources being expended on a particular unit, and how many possibilities there were of something that we would have to look into for each unit. If a unit only has one connector, if the unit's damaged or the connector's not working, that one's done. And it's not, until it gets fixed, nothing else can happen with it. We're not going to get any more complaints. Meanwhile, on the multi-connector one, if one of the connectors isn't working, then there's 7 other connectors that are working and could, be the source of complaints. Also, I would assume if you've got multiple connectors, those have to be separately maintained and tested and calibrated and all that kind of stuff. And so it's more records, more complaints, more calls in theory, if it just had one connector.
Okay, so for the 6 connector station, we would be charging $30 per connector.
Yes.
Okay.
6 when you say state, yes.
Yeah. Okay. All right.
Of course,
Mr. Chamberlain.
It's easy for me to say unit. I know y'all hate that, but if the unit has 6 connectors, we be charging $30 for each connector on that unit.
Right.
Yeah.
Right.
So we need to define what a unit is. I'm the one that brought up the multi-connector issue, this is George. But if we can define what a unit is, like when because depending on the type of EVSE, you could have multiple ports, but it only charges one car. So it's one EVSE, one unit. If we have a station that can charge multiple cars at one time, we would consider it, multiple IDs, because each one of those has to have its own meter. It has to be calibrated, has to have a sticker on it. Everything, it'd be treated as a separate EVSE, even though it's all coming from one power cabinet and power sharing, and it could be multiple dispensers, one power cabinet with multiple dispensers with 2 or 3 cords coming off of it, each one. I hope I didn't make that sound too confusing.
I hope not. I just wanted to clarify that the charge or the fee for each connector is not like some kind of a tax on the ability to charge multiple cars at one time, or charge, have multiple ways to charge a card. It only had to do with the possibility of expending resources by the department. And
there's 2 ways that machine could break. Like, you could have the power cabinet go down and it takes all 8 ports out at once, or 6 ports or 3 ports, whatever it has. Or you could have the dispenser go down and the power cabinet still be fine and all the other ports still working. It just, so there's different possibilities of what could happen.
Okay. If I can jump in, Michael Chamberlain.
Yeah, go ahead, Michael.
So I think this comes back to really defining what charging unit is. And if we're going to say EVSE, we need to say EVSE, because in 9680A, we're mixing things. We're saying initial registration for newly registered charging units and additional units per connector or plug. Because what I hear you saying, Mark, is like, you said, oh, we're doing this by port. This does not mean port. So you can have one port and have multiple connectors, but only one connector can be used at a time. Or you can have one port that shares power and you can power 2 cars at a time, 3 cars at a time. Okay. So
that's correct.
So what we need to do is we need to fine tune this so that it's either the charging unit or EVSE or whatever you call it, or it is just connector, and remove charging unit from 9680A. Okay, because if you're saying that it needs to be by connector, fine, whatever, we don't care. You're saying it's every year, fine, we don't care. But be consistent so you're not mixing things. Right now you're mixing things. The other thing is the sticker, you're just getting one sticker, correct?
Right.
One sticker per dispenser or per EVSE. You're not getting one sticker per connector or plug.
Right.
And my last, okay, so that's important, because if you're doing this by connector or plug and each have their own individual fee, well, it kind of makes me seem like you should have a sticker for each one of those fees, but we're not. We're putting the sticker on the unit, the dispenser.
Okay. Right. The sticker is going to be on the dispenser, but the dispenser could have 4 connectors.
Right.
So,
and if it's a single port design, you can only use one of those 4 connectors at a time. In the scenario, I forget who said about it, that, if one connector doesn't work, go to the next, go to the next. That's not a scenario that's going to happen. Your vehicle is going to have one port If that port doesn't work for your vehicle, you're not going to just switch to the other ones. If you had some type of adapter, maybe, but people don't carry 7 different adapters. So that's not really a use case. So I think we just need to we need to define what we're going to do with charging units. Just to do something with that. And if you're going to make it by connector or plug, that's fine. You got to clean that up. So there's no confusion. Because right now, the way this is, if I'm talking to some of our NEVI awardees, I don't know what to tell them to pay. Because the charging unit is one thing and the connectors are something else. That's my point.
Okay, so what language, at least here in 80, would you want us to change here?
So the comment that I suggested, again, was change per connector, per charging connector / plug to per charging connector / plug when power sharing is supported, otherwise per port.
You broke up that last part with power sharing what?
So per charging connector / plug when power sharing is supported, otherwise per port. And then everything makes sense. So if you're doing a fee per connector and that connector can power multiple vehicles at the same time, great, no problem. If you just have one port and one connector, no problem. If you have one port, but it can't do power sharing, so it's only charging one, and you may have 4 connectors, but you only use one at a time, that's what you pay for. And then that leads me to another question. So as an example, like, I don't know, I'm asking here. What is it, how is it done on a liquid fuel dispenser? You may have multiple nozzles, different grades. Do you pay per nozzle or do you pay per dispenser? Does anyone know that offhand?
Mr. Chamberlain, you said what type of fuel were you talking about?
Liquid fuel, just liquid fuel, gasoline, diesel.
Gasoline.
Liquid.
It's charged per I guess for like per octane type. In other words, if you go to a pump and it's got unleaded, super unleaded, and premium, they're paying for 3. They're paying a fee that's 3 times than if there was just one type of fuel coming out.
So that's consistent with what you're saying here, except
Yes.
the confusing part is the charging units. That's the part that's confusing.
And
because those are not the same.
Quick, sir, what Mark wrote, your suggested language, you ended with port, correct? Not plug?
Per port, not plug.
Per port, yeah.
Per port. And so, yeah, Mark, so it'd be per connector or plug where power sharing is supported, otherwise per port. And there's some other people with hands up, so please chime in if that's.
Yeah, I'm just thinking about this. Is there a way to just make it a flat fee and not have to track all of this information? I mean, to me, how many ports you have is a market decision. And yeah, it means you have more cables, more connections, but I'm just thinking of having it easy, simple, so everybody understands. Like you said, Michael, you wouldn't know what to tell somebody right now under NEVI. So is there a way to even simplify this further and just identify one fee and let the market decide how many, different connectors and, charging leads coming off the power unit?
Yeah, I think it comes back down to that charging unit thing. You have to call that an EVSE and make this a fee by EVSE, or take out charging unit altogether and just say initial registration or initial registration per charging connector / plug.
Well, yeah, I think that Mr. Wilson's suggestion for the charging unit definition to add in a cross-reference to EVSE, might help, clarify a little bit.
Sorry to interrupt, but I don't think so, because those are two different things. So you can have multiple connectors or plugs as part of your EVSE.
Yeah, so
because-
I was just going to jump in, Michael. I do think that this is, so I think there's a couple of different, kind of levels that we need to think through this. I think we need to think through it from what is the granularity of the information that TDLR needs to do its job. That's a very important consideration, obviously. I think the other, very important consideration is, like, whatever we decide, connector, plug, unit, however you decide to price it, we need, like, we do not have a definition up above for connector or plug or port. All those are kind of used in the industry, with some slight variation. I do have a link to a Department of Energy website that kind of, I think, visualizes this. I think a visual might be helpful. I could do one of two things. I could put it in the chat, and Mark, if it's your computer, you could pull it up. I could try and share it. And I think it gets to some of these kind of concepts. Not all of them, unfortunately, but I could also just follow up in comments. But I think my number one comment is, I think we've been talking about, like, how to explain this kind of internally to TDLR. We need to think about the person who owns the coffee shop and they're going to try and register this thing, and they're trying to figure out, I think, Michael, your comments kind of got to this, it needs to be very clear to them, like, what they need to register when they're trying to do it. And right now I'm a little confused.
Well, what if we put a definition in there for at the top for charging connector? And then and we still charge, would we still be able to charge per charging connector? Or we would just have to charge per the charging cabinet?
So is that a question for?
I think it should be,
That's a question for any of the work group members.
probably should charge based on how many vehicles can charge at one time on any specific unit. And the vehicles are going to charge on the ports, or connectors, as you guys are calling them. So, I think it should be a simple way to do it, because when you install a charging station, EVSE, one of the questions will be, how many vehicles can charge at one time? Well, on this one, 4 vehicles can charge at one time. Or this one, even though it's got 3 or 4 plugs, can only charge 1 vehicle at one time.
Agree. 100%. Agree 100%.
Yes.
How often do we encounter a charging cabinet that can charge 4 at one time? Is it just one time? One per vehicle, or most of the time?
No, it used to be 1 per vehicle in the beginning, and then we had multiple connectors. So then we had chargers with multiple ports, because you needed a different connector, kind of like having an unleaded and diesel on one pump. And the new chargers were coming up with bigger and bigger power cabinets. We can now order a 1 megawatt power cabinet. So when you got that kind of power, you can now build a dispenser with 2 ports, or if you're really creative, build one with 4 ports and put it between 4 parking spaces. The reason we like to charge multiple cars on one dispenser is it's cheaper to install. And so it's more of it's a newer thing coming, the newer, I don't want to say newer technology, but the designs are changing such that we're looking at more fleets and, the need for more chargers. And so, the options are now we can buy dispensers that can charge multiple cars.
And this is Michael with NEVI. I can say about 30 to 40% of our installations will be units, right? EVSE, whatever we're calling it, they can charge 2 vehicles at the same time. And that's kind of the NEVI is like remember it's 4 by 150, 4 ports by 150 kilowatts. So you'll have 2 dispensers that feed 4 spaces, and each dispenser can charge 2 cars at the same time. It's a very common setup, kind of like a base NEVI setup. So we're seeing lots of that.
Okay, I'm still a little fuzzy on this, but Tony, what I'm concerned about is what would be the fiscal impact? And I know it'd be hard for you to do it on the fly right here, but I'm just concerned if there would be an increased cost to the public
I don't
based
think
on.
so, Mark. Based on, what they're saying, I guess my thought is, or what was and is, that it's more of what they were saying about how many cars can be charged at one time is what was the thought behind it. I didn't intend for the charging, like y'all were talking about. You'll have a unit and it'll have 3 or 4 connectors on there that are different types to fit the different types of cars for their needs. It wasn't based on that. It was based on, a unit being down or a connector being down and someone going to the next connector over on the same unit and also having a problem, and someone going on to the next connector on the unit and also having a problem, and it resulting in 3 complaints off of 1 unit that only paid 1 fee. So it wasn't designed to, someone goes to the, and I'm sorry, I don't know the names of the different connectors, but if someone goes to the unit and this connector is broken and this connector is broken, that's multiple complaints. Talking about 2, because do they come off the same cord or are they on different cords?
Well, it comes off the same charging station, but it has different connectors.
Not always. Depends on the station design. Also uses 1 cord.
Right. That's.
But we can have 2 connectors on it because we have a permanently attached adapter.
Mark, I sent you a link to a graphic that the Department of Energy has. I don't know if it makes sense to show that. And I continue to think that port is the appropriate metric here, but I do think it's worth maybe aligning people on what that means.
Yeah,
I'm going to
I
see if
think
I
it's
can.
hard for people
I'm going
to
to see if I can.
visualize.
I'm going to see if I can share this real quick.
Justin, to continue that and for deeper understanding, can you tell us what port means to you?
Yeah, so I think we can take, and this is a definition from this Department of Energy page, a port. An EVSE charging port provides power to charge only 1 vehicle at a time, even though it may have multiple connectors.
And that's how we understand it as well.
So that graphic there in the center. So if you start at the top, the station is the overall location. So I think you could call that an address, more or less. These gray units, and I don't think I can circle on this platform, but the gray units would be the electric vehicle supply equipment, the EVSE, or the charging unit. Then you've got these green lines, which are essentially the EVSE ports. And you can see that if you work your way from left to right, the 2 on the left, each port has only 1 connector coming out of it. However, on the far right, that port has 2 connectors, 2 hoses coming out of it. But on the right, those 2 hoses run up to the same meter, essentially, or run to the same kind of, that you can only charge 1 car at that port. I think over time that instance on the right, far right, is going to become obsolete. we're moving slowly. I think beyond, having multiple hoses, so to speak, on the charging stations themselves, the EVSE or the ports. So I do think that largely you can align around these definitions. I think we need to, insert the EVSE definition for those gray things there. But other than that, I think these definitions could hold true, and you charge based on the port at the end of the day.
If I could jump in real quick and just remind the members to please have your video on, please.
And
I
this
think
is Michael. Sorry, not to make it any more confusing, but Francesca
Go ahead, Mike.
mentioned this, that there are some units that have a permanently attached adapter, that it can be essentially two connectors, but it's housed in one assembly. And there are other companies that are doing the same thing. So it's going to get murky if you're saying, well, I can pull the hose on one, and sometimes it's A and sometimes it's B. Still one port, still goes into one dispenser. But how do we apply this to that scenario? Do you say even though it's one cable coming out of one dispenser, but it's got an interchangeable head on the end of it? Does that mean two? Not to make it more complicated, but again, I don't know what to tell people. But if we get away from trying to say connector or plug and just make it port, that's very clear. Any other comments on that?
So moved.
I think we're probably going to have to do a slightly, more in-depth dive into port versus connector. I think we just kind of, staff probably needs to sit down and talk about it. I think we can figure it out, but this diagram helps out quite a bit, and it also has some information that we can look at. My only concern is how this, what type of fiscal impact does this have? If we were to do that. Okay. We've only got a few more minutes left, and I'd like to finish up the last little part of
Hang on real quick, Mark. I'm sorry. I think I heard one more comment about to come out though.
Sure.
Yeah, sorry, I was just going to say, in case it helps you all, in other states where you have to register your devices, the common way to do it is you register your EVC, and then they have a selection of, do you have 1, 2, 3 plus ports? So they use the terminology port. So if you're thinking about consistency across other states, it's EVSE tied to port, essentially. So I just
Other
wanted to
states are
mention that.
using ports.
Yeah, they're basically you're paying a fee per EVSE, not per port, but they want to know how many ports you have, and so they use the term port to know how many ports you have. They're not asking about connectors.
Okay, and you're paying, just real quick, because that was important information. You're paying the fee for the
EVSE.
EVSE regardless of the number of ports.
Correct.
On the fee calculation.
Yeah,
however,
on the fee calculation.
The information on number of ports is being captured.
Correct.
Thank you.
Okay. Let me share screen here real quick so we can finish up. Go. Where am I? Okay. Okay, then we'll probably have to, as I said, staff will have to discuss that particular section and determine, how we can charge based on ports. Okay. All righty, moving on. We 9683 the only changes here that we made was pursuant to comment. There was a request to be a lot more specific as to which sections of the NIST handbook that we were using, both in handbook 44 and 130. So we added in those particular sections that were germane to that particular issue. We have a hand up.
Sorry, just on 9680, which is kind of hidden between what we were just talking about and so down a little bit, the fee disclosure, fee policy and disclosure section. You guys didn't make any changes, but we did comment on the fact that as an industry, again, if you're providing the information on the EVSE display or the provider's digital network, that does take some development work and integration work. And so we had requested additional time, like an additional compliance period beyond March 1st, to allow folks to do that development work, because like you would already need to be doing the development work right now in order to actually potentially get it on the station. And that was not addressed. And so I just wanted to understand why.
Okay, and I do remember a comment related to that. And again, that was related to the 9614 operational exemption.
Yeah, but we're
So-
talking about stations after March 1st, even. Like if you
Oh,
want me to
even-
have it on a station on March 1st, my
Mhm.
development team would have to be doing that work right this moment to be able to like do that. And because it wasn't on our digital roadmap, like I probably can't get it in there, right?
And Francesca, are you saying on the display? Is your
The
comment
display or the app, whichever one you're talking. If you want it digitally,
Okay.
yeah.
or on the network as well? That's the challenges you described would apply to the network as well?
Mm-hmm.
Okay.
Yeah, so it was just asking for an additional small time chunk to be allowed to do that after March
Okay.
1st. And this was in the industry letter, and then Tesla talked
Yes.
about it as
Yep.
well.
Mhm. So how much time would you need? You say a year?
We put in our letter a year. I mean, it will vary across networks, but anytime you have to do something bespoke that is not consistent across the entire country, like that includes development work, it will just take at minimum, I would say, depending on the company, 6 months, because you have to
12.
get it on your product roadmap.
Okay.
And we don't have to do this anywhere else. Texas is the only place we'll have to do it.
That might be a provision that we could stick in here just for this particular provision. It might be something we could put in there.
Okay, great. Thank you. Just wanted to point that out.
Okay. Moving on to subchapter F. This is basically standard enforcement language that we put in for all of our programs, both in 9690 and 91. There was a comment by one commenter that wanted us to basically include a 60-day cure period before we imposed a penalty, and staff chose not to include that in the rules. We don't do that in any of our programs. You know. So, all right. Any questions or comments on subchapter F before we move on? Okay. Subchapter G, last thing. We had a comment that requested that we be more specific about handbook 44 and 130, like we were in 9683. So we added in sections 3.40 and section 2.34, and those are the only changes that we made pursuant to comments on that. Any questions or comments on subchapter G? Okay, hearing none, that concludes the presentation on the rules. There's a hand up.
Yeah, not on the rules. Given the discussion today, and this work group's potential dissolution in December of 2024, has the department considered extending it and keeping the band together beyond that date?
We haven't had extensive discussion about that yet. But I do anticipate, continuing to use the group. You know, we mentioned the testing of the licensing system, for example. So I do expect that we will continue to reach out to you. If that answers your question, comment.
Yeah, was hoping for more gusto, but that'll work.
Well, based on all the overall comments I gave at the beginning of the meeting and the very important discussion we've had today, I don't see this relationship ending anytime soon. Brian, if that's a little more helpful, as I said, we need to understand the industry and where you all are, and you need to understand us. And so I see that as an ongoing relationship, and I see that this group that's already been put together for this purpose it can serve well in the future.
Yeah, no, I wholly supportive of, you know, this group in essence is we're developing our shared vision for this program.
Yes, sir.
And we're doing it together.
Yep.
And we're listening to each other. And, you know, I think, you know, it's a rare opportunity that you get this type of collaboration, and would just encourage the agency to continue to nurture that and let
Yes,
it grow.
sir. Thank you. We intend to continue nurturing that. Yes, sir.
Great.
Thank you.
Thanks.
Steve, I guess we move on to the next agenda item.
Well, I mean, it's recommend, these are standard agenda items for quote unquote standard work groups. It's a little bit different in our case. You know, I don't know that we have recommended items for a next meeting or when we might meet next. I do know that we've got some important comments to continue considering today. We have a commission meeting coming up in October, and I would encourage anyone to attend and provide your comments there. Mark, can you talk a little bit about how you see the next couple weeks playing out?
Okay, basically, after this meeting, of course, staff will probably get together, you know, what's left of today and probably tomorrow, certainly to discuss the comments related to the fees and probably the comments related to possible definitional amendments, so that we can kind of address the fee discussion. Once we do that and make maybe a few little minor changes, I think that we still could be ready for the 23rd. You know, of course, we'll still have to talk about that to see, because you know, I think we need to come to a decision on the fee situation. But let's get together and talk and sort of work this out. And we may want to reach out to the work group members again with regard to those two particular issues, and you know, make some possible refinements. You know.
Okay. That sounds good.
Anything else?
I don't think so. I again just want to thank everybody for your time and the continued effort that you all are putting into this. I appreciate your perspectives. Again, they're very needed, and I think nobody's corrected me. We're going to be the 5th state to adopt rules on this. So it's exciting and challenging, and I appreciate everyone's input, and we will take everything into consideration and continue our discussions with you. Thank you.
Thank you.
And at
Thanks all.
4:37, we'll call the meeting adjourned at 4:37. Thanks.
Thank you.
Bye.